Welcome to Fire Inspection and Code Enforcement and Chapter 1, Duties and Authority of the Fire Inspector. The first learning objective for this chapter is going to be to describe the duties of a fire inspector. We have to know why governments have fire inspection and code enforcement offices. And the short answer for this is to protect lives and property from uncontrolled fires and other hazards. The fire departments of today have truly become an all hazards, all risks organization and do not deal solely with fires. We're going to explore who is responsible for certain types of inspection programs, because there are a number of agencies that interact with each other and the titles can be confusing across those lines. The agencies are typically the fire department, the building inspection department, the code enforcement department, which sometimes can be part of the building department. There are also insurance underwriters, and those insurance underwriters normally assess the risk for a particular commercial occupancy before they write a fire insurance policy for it. And very often those insurance underwriters will utilize a third-party compliance certification company in order to complete the inspections on their properties. It's not just the insurance underwriters, however, that use third-party agents. Some municipalities, especially smaller ones, will use a third-party agency to perform their fire inspections and sometimes building inspection duties also. It's simply more cost-effective to do it that way. Within those organizations, we can have fire and life safety inspectors, which typically belong to the fire department and the Fire Prevention Bureau. We have code enforcement officers, which can be building inspectors, strict code enforcement officers that enforce the fire and life safety code, or the property maintenance code rather, and then we have other types of inspectors that may be specialized. An inspector one has to know what's required to perform his job properly, and he has to have a good understanding of what his assigned duties are, and he has to be able to apply the correct building code provisions to what it is he is looking at. And it's important also to know how the building code provisions relate to one another, how the fire code relates with the building code, relates with the property maintenance code, etc. And they have to be intimately familiar with their authority, or more importantly, the limits of their authority, so that they don't overstep their bounds legally. The inspector should familiarize himself with all the legal resources that impact your duties. And we start with statutes, which provide the legal basis for inspection and give the inspector their legal authority to perform their job. The statutes establish a minimum requirement that must be met in order to be compliant with the code. And the statutes also set the limits of the authority of the department and of the inspector. The codes and regulations that are adopted by a particular jurisdiction detail the fire and life safety requirements that must be met by all properties within that jurisdiction. And they usually outline in detail the duties of the fire inspector. Other than inspection duties, the permitting processes are usually handled within the inspection department or the Fire Prevention Bureau. And a permit is simply gives the inspector an idea of what is going on in the community, so that they can now go and inspect it and make sure that all the proper provisions of the code are being met. For example, you want to have a fireworks display in the park on a holiday. Well, you need to apply for a permit for that fireworks display, which then triggers automatically an inspection by the Fire Prevention Bureau to go and make sure that all the proper provisions of the Fire and Life Safety Code are being applied. The ordinances that are adopted by your particular jurisdiction are extremely important because, again, they give you the legal basis to be able to do your job. And more importantly, if somebody is not complying with the minimum code standard, it gives you the ability to enforce it in a court of law. The duties that the Inspector 1 performs range from investigating citizen complaints, performing programmed and systematic fire and life safety inspections. They could be out verifying the water supply flow capacity or flowing the hydrants and taking readings to make sure there is adequate fire protection water available. They also interpret the codes and standards to make sure that a particular code is being met at a particular location. Excuse me. They may be called upon to determine the safe occupant load for a single-use building. They're also called upon to apply the specific codes and standards to a given situation in their jurisdiction. And they may be called upon to participate in legal proceedings, should a legal action be necessary. The inspector may be an employee of the public or of the private entity, and their duties can vary. Typically, the inspection programs are going to be found in one or more public organization. They're either going to be in the fire department, usually in a separate fire prevention bureau within the fire department, or they may be within the building department, which is usually a separate municipal department. And there could be a third separate entity called the Code Enforcement Department, although in most municipalities this is rolled into the building department. Fire prevention divisions can be staffed in several different ways. They could utilize non-sworn personnel or civilians. They could be sworn personnel, firefighters, or it may be some combination of the two. The building inspection department is almost always staffed with civilian employees. Those inspectors review and approve all new construction plans submitted for a particular jurisdiction. They also review and approve all alterations to existing structures. For example, somebody wants to build an addition onto their house. They have to submit plans to the building department, and those plans have to be reviewed to make sure that all the applicable building codes are being met. The plans review process is a very detailed process, and usually only more senior inspectors conduct the plans reviews to make sure that all the proper code provisions are being addressed before the construction takes place. They then issue permit for the building to be constructed, and as it's being constructed, they perform field inspections to make sure that at each stage of the construction process the codes are being met. The inspectors in the code enforcement departments sometimes conduct fire inspections. They respond to citizen complaints. They may be enforcing parking violations, weed abatements, unsafe vacant structures, unauthorized water usage, usually from a fire hydrant, and pyrotechnics displays, and also the special category of tents. In warmer weather especially, we will see tents pop up in parking lots of commercial establishments, usually for a large sale type operation. And these tents, even though they're temporary structures, do have to meet certain provisions of the building code and the fire and life safety code. The third-party inspector have duties very similar to those of the public inspector. They're not limited to the public sector, however. As I mentioned, insurance companies employ a large number of contracted third-party inspectors to go and assess the fire risk for their properties. The third-party inspector could also perform plan reviews or conduct inspections of any type that they happen to be certified for. And they're usually employed by third-party inspection services. These services usually contract themselves to a local municipality. In a lot of cases, it's a small municipality that does not have enough volume to warrant a full-time employee to do the inspections or the plans reviews. Private fire safety inspectors usually work for insurance companies. They function as the risk assessors for that company, and their scope and power varies widely. Generally speaking, they are a technical representative or a subject matter expert that provides an expert opinion as to the risk level that it would be assessed to that insurance company should they choose to represent that building owner and cover their property. The insurance company usually dictates the relationships, and they dictate the policies and procedures for their inspectors. They need to have good relations with the public sector inspectors. There is a good deal of goodwill that goes back and forth between the public and the private sector inspectors. Inspectors need to be aware of training and certification options, and they must be trained to a minimum level of training. The authority jurisdiction normally adopts national agency, state, province, county, or municipal standards that have to be met, and these typically fall around a professional qualification standard, such as NFPA 1031, the standard for the professional qualifications of a fire inspector. There are courses and continuing education materials available from various sources, such as the International Code Council, the National Fire Protection Agency, or the National Fire Academy, that are all geared to the Inspector 1 level. There are several certification levels that are available to inspectors. And not just dealing with fire inspectors, but also with residential building inspections, commercial building inspections, code enforcement qualifications, special inspector qualifications, general inspection qualifications, and code official or building official for the municipality. And then there's the master code professional, reserved for only the highest skilled inspectors in the business. These people generally have multiple certifications and are truly subject matter experts in their field. There are also continuing education courses available to the inspector and should be taken advantage of. These could involve report writing, communication skills, ethics in government, code enforcement principles, personnel issues, public speaking, stress management, case development, and courtroom and evidentiary procedures. The categories of fire and life safety inspections range from the routine or the programmed and systematic inspections done on the properties in a jurisdiction. These are performed on a set basis and are usually based upon the occupancy classification. Certain occupancy types, such as assembly occupancies and schools and churches especially, normally have to be inspected annually. Other lower hazard classifications can sometimes be inspected on a biannual or even a triennial basis. The permit process is conducted when an owner or occupant wants to obtain a permit for a special event or an occupancy uses. In other words, if a building owner wanted to, let's go back to the tent example, wanted to have a big tent sale at his store, so he calls a rental company and they come and erect a huge tent in his parking lot. Well, the sides are now put on the tent because they're expecting rain. Well, this now becomes a temporary structure, and it needs to be sure that there is an adequate egress, and in some cases they may have to put temporary exit signs and lighting in, depending on the provisions of the code. Them applying for this permit puts that tent sale on the inspector's radar, and they now come out and inspect it. Now, there are lots of times when a permit is not pulled and the event happens without the benefit of a permit, but that can put the building owner in extreme jeopardy legally should something bad happen. There's also the complaint response, and whenever a resident or business owner files a complaint, it's usually done in writing, and the inspector then is dispatched to go out and investigate that complaint and determine if there truly is a code violation issue. There's also the imminent hazard category of safety inspection, and this is reserved for the most egregious and the most serious cases. This is what happens when there is an extreme hazard to life safety in a building, and sometimes the occupancy permit for that building can be revoked and the building padlocked until the issue is corrected. These are extremely rare and should be pursued only in the most extreme situations. New constructions generally have inspections done by the building inspection department. These are done when the structure is built, and they're conducted when changes are made to an existing structure, including demolition. A change in occupancy also triggers a category of inspection, and these are done whenever the building goes from one use to another. Let's say, for example, a supermarket moves out of a large commercial occupancy, which would be a mercantile occupancy. But now a megachurch wants to move in there, and that is an entirely different code provision and has to be adhered to for an assembly occupancy. That inspection would be required for code compliance to make sure that that change in occupancy can be done safely. Also, not common, but it does happen, the owner or occupant may request you to come and do an inspection and do a walkthrough of their property. And somebody that is that proactive is usually going to be very willing to bring their building into minimum code compliance. This could also be required by a government or an insurance agency. The Memorandum of Understanding is a very important document, and it's used when sharing inspection responsibilities across departments. This typically involves outlining the specific responsibilities for each type of inspector. In other words, the building inspector is not going to enforce the fire code, and the fire inspector is not going to attempt to enforce building codes. Once that clear delineation is made, we don't have people muddying the waters and confusing the residents with different inspectors showing up to enforce the same statutes. Our second learning objective is to describe the legal guidelines for inspections. Inspectors need to know the answers to certain questions. Is noncompliance with the code a violation of criminal or civil law? And what process has been employed to attempt to achieve compliance? Have accurate records of all the correspondence, communications, and personal contact been kept in accordance with local policy and law? And will the possible penalties induce compliance? We have to understand that compliance with the minimum standard of the code is the primary goal of all inspections. However, sometimes stronger measures are sometimes needed to gain compliance. We have to be familiar with the concept of due process. The accused rights must be protected, and this includes the property owner. The two due process clauses in the United States Constitution are in the 5th and the 14th Amendment. The 5th Amendment, of course, provides that the individual does not have to say anything that may incriminate himself. He has the 100% has the right to remain silent and not say anything. And under the 14th Amendment provides for equal protection for all under U.S. law. That is, we could not enforce the codes against a particular property owner and then selectively decide not to enforce it against another property owner. That is specifically forbidden under U.S. law. Compliance infractions can be handled in several ways. They can be in the form of a notification, which would be a form letter or an inspection report that describes the infraction. The follow-up inspection, usually 30 or 60 days in a predetermined manner, then goes back and inspects only the infractions that were found in the first inspection. If those code violations have not been corrected, sanctions can be taken in the form of citations against the property owner, complaints with the magistrate, fines, a stop work order could be issued, and a summons to appear in front of the magistrate. And the prosecution is usually done if the building owner fails to correct the issue and can involve witnesses and courtroom advisors. The inspector should understand the prosecution process. They present the evidence of what they found in the inspection. The defense or the property owner makes their arguments, and then the magistrate weighs the evidence and arguments and renders a decision. Civil proceedings involve one party filing suit against another party and may be the result of a non-criminal action. Example, a breach of contract. One property owner could have a contract or an agreement with another property owner and then fails to meet his part of that agreement, and that may end up in court. You may be called to testify as to your experience with the code and your knowledge of the code as applied to that particular situation. In a bench trial, the judge determines the outcome. However, in a jury trial, a jury of the accused's peers are impaneled and they render the verdict. Criminal proceedings can involve various steps according to the jurisdiction. The steps involve when the alleged crime or violation occurs. The investigation then derives information as to probable cause and may cause an arrest warrant to be issued, and then an indictment handed down. The criminal proceedings in court may include a bench trial or a jury trial, and if found guilty, the judge or the jury metes out the punishment that is to be made. The three levels of criminal violations in the United States justice system involve summary offenses, or the most minor infractions. These usually involve a simple citation and a fine being levied. A misdemeanor is the next level. It is a lesser crime, but it is still a crime nonetheless, and usually involves a fine or less than 2 years in jail as a result of a conviction. This can result in a trial, but not always. Felonies, on the other hand, are reserved for the most serious crime. A conviction of a felony can involve a fine, prison sentence, or even death by execution for the most serious capital cases. Inspection records may be needed as evidence in court proceedings, and it's important to understand that every single document that the inspector creates or documents in the course of his duties are discoverable in a court of law. That includes digital recordings, photographs, paper notes, and inspection forms, and any correspondence with that property owner regarding a certain issue. If a violation is found, normally the property owner has 30 or maybe even 60 days to abate that issue. If it is a serious hazard to fire and life safety, it may need to be rectified immediately, but these are rare. The inspector must know the legal requirements for entering the premises. Hazards in plain sight may be recorded. However, they may not be admissible in court if obtained without either a search warrant or a scheduled visit. A wise inspector will always contact the property owner and schedule an appointment to go and conduct the fire inspection. This is important for several reasons. First, it builds goodwill with the property owner, and secondly, the property owner consenting to you being there in the eyes of the court means that they invited you onto the premises. So anything you now find will be admissible in a court of law, should it come to that. If the property owner refuses to allow you access to the property for the purpose of conducting a systematic and programmed fire inspection, then an administrative bench warrant may be required to be obtained from a judge before you can enter the premises. And this normally will involve law enforcement activity in order to enforce the order. These should be done in only the most extreme circumstances. The inspectors are always considered to be part of the prosecution. They are on the side of the state or the authority having jurisdiction. They present the fire code as it is applied locally. In other words, the model code plus any local amendments. They assist the prosecuting attorney in building a case against the property owner. The inspector provides information on fire ordinances, technical terms, and facts, and should present unbiased expert testimony. A preliminary hearing takes place before a judge, and this is where the prosecutors establish that a crime has been committed. If the prosecutors present a strong enough case that the crime has indeed been committed, the accused is then bound over for trial. In the case of a felony trial, this takes place before a judge or a jury and has a much higher burden of proof upon the authority having jurisdiction. The prosecution presents its case first, and the inspector may be called as a witness. Before setting foot in a courtroom, the inspector should be familiar with courtroom procedure and behavior. He should review all files and notes before going into court, stick just to the facts, remain impartial, and never volunteer information. On the stand, you should be brief, factual, and truthful. And if a question is asked of you that you do not know the answer for, you say, "I do not know." You should, however, be aware that the defense attorney may attack you personally, including your credibility, your ethics, and your knowledge of being a subject matter expert. They are going to challenge you in any way they can to weaken the prosecution's case. There are two categories of testimony. You can be a fact witness. You present facts without interpretation, and this is limited to what was seen, touched, smelled, tasted, and heard during the inspection. The other category is the expert testimony category, and this provides opinions, and you must have sufficient skill and expertise. These are usually designated by the court, and you may be called in to testify as an expert witness for a case that you have no prior knowledge for. In that case, your testimony would be solely based upon your skills and your expertise. So in summary, inspectors are really responsible for ensuring that the jurisdiction's fire and life safety program is successful. They do this by performing their assigned duties, reviewing plans, issuing permits, inspecting new and existing facilities, and responding to complaints from the community. Inspectors may be private or uniformed, or non-uniformed public employees. This concludes Chapter 1's lecture, and after reviewing Chapter 1 in the text, you should be ready to take the Chapter 1 examination.